It's now my pleasure to introduce Marc Mangel, who's professor at UC Santa Cruz.
So I'm actually going to talk about one such treaty today. I served, it's the PDF. I served as the independent scientific expert for the case I'm going to talk about today in the International Court of Justice between 2010 and 2013. The decision came out just about 2 years ago, and I think it is going to have profound and long-term effects. And once we get to my slides, I can, no, it says Mangel. It's a PDF. No, it's the other one. Yeah, that one. Oh, because it was on my thumb drive. Do you need the thumb drive back? Well, I think, yeah, but maybe you didn't drag it to the desktop. Okay, and there we go. Okay, so I decided to talk about this, not knowing what Scott was going to talk about, but I did it for 3 reasons. The first is that whales are probably one of the top 2 iconic or totemic coupled human natural systems, the other being salmon. The second is that this case is really about standing up for science, which is a phrase that Nature uses when it gives out the John Maddox Prize. Now, usually when we talk about standing up for science, we're talking about the demarcation problem. What separates science from non-science? Right? Astronomy is science, but astrology is not. Right? This is what I call the stones versus house problem. The question is, can we not just collect data and say that we're doing science? As long as we're collecting data, are we doing science? Poincaré, many, many years ago, said no. He said, sure, science has facts and data, but just collecting facts is like calling a pile of stones a house. The third reason is that this case was about communicating science, which everybody in this room should be interested in at some level. These are the 16 judges who were involved in the International Court of Justice. They are all qualified to be on the Supreme Court of their own country, and they're all very smart and accomplished, and in general, they have no scientific background. The exception is Joan Donahue, who is the American, it's this one, let me try this. The American judge who actually has a bachelor's degree in biology from UC Santa Cruz. Some of the other judges are, and I've shown here, are Kenneth Keith, who has left the court just now. He was the judge from New Zealand, and he and I had a wonderful exchange about Adam Gopnik's book, Angels and Ages. This is Chris Greenwood, the British judge, who wrote a very strong separate opinion after voting with the majority, and Yoro Gaia, who I saw in Oxford a little bit less than 2 years ago, who talked about evolutionary interpretation of human rights treaties, and that will come up as we go. So the background to this is that there is an international treaty, the International Convention for the Regulation of Whaling, the ICRW. It was the 3rd attempt, this one ratified in 1946, by the whaling nations to do exactly the kinds of things that Scott was talking about, of figuring out a way of self-regulating their harvesting of whales. That treaty recognizes Aboriginal whaling, and actually, I don't want to hit Canada again, but Canada withdrew from the ICRW many years ago because of the Aboriginal whaling issue. Commercial whaling and scientific whaling in Article 8 of the treaty. What Article 8 says is that a government can authorize permits for its nationals to kill whales for purposes of scientific research. So as I go through the talk, I want that phrase to stick in your mind. What does it mean for purposes of scientific research? The article goes on to say that, and the whales killed in this scientific program will be exempt from operation of the convention. So Japan's interpretation of Article 8 was that as long as the work was associated with Article 8, there were no obligations to the other members of the group. No cooperation was required. The preamble of the ICRW says that the purpose of the treaty is the proper conservation of whale stocks to make possible the orderly development of the whaling industry. And between 1946, when it went into effect, and 1982, the IWC failed miserably in doing that. So this is a take of the 3 or 4 main species. Beginning in 1904, when the first pelagic whaling happened, through about 1970. That red line shows when the ICRW went into effect. So the consequence, as you see, is whale catches were very high, and in fact, the highest whale catch happened right there, long after the ICRW went into effect. Because of that, the commissioners tried over many years to develop alternative management strategies. One was called the Blue Whale Unit, one was called the New Management Procedure. And then in 1982, they voted that effective 1986, there would be a complete commercial moratorium on whaling to allow stocks to rebuild and the development of a revised management procedure. Now, the commissioners did this, I think, because of something like this, that they realized the only way to actually control this allegedly cooperative behavior was to have no cooperation, no commercial hunting at all. Because they realized one species might be sufficiently strong to sustain a take, but there was no way to control what would happen to everything else. At the time that pelagic whaling started, here are estimates of population size of bluefin and humpback whales. These are the estimates. The middle bar are the estimates at the time of the ICRW going into effect. And those little bars down there, that's 453 blue whales. Those little bars are what was there in 1982 when the commissioners voted for the blanket moratorium. Okay. Simultaneously with the start of the moratorium, Japan initiated what was called the Japanese Whale Research Program under special permit in the Antarctic, JARPA. And Japan authorized the take of 400 minke whales every year. These vessels that have research painted on them were commercial vessels before the year began and became research vessels once the moratorium went into effect. The objectives of JARPA at the beginning were these two, estimating biological parameters. These are actually no longer relevant because of the way the revised management procedure works. Elucidation of the role of whales, and then about 10 years later, 2 additional objectives were added. Now, if you look at those things, they are so broad that it is possible to do anything you would want under the guise of those objectives. Yes? You mean the commercial whaling? There were more commercial whales taken. The review of JARPA began in 2005. It was completed in 2006. The second program began in was proposed in January of 2005 and began in November of 2006. In other words, the second program began before the first program had been reviewed. Under that program, Japan issued permits to take 850 minke whales, 50 fin whales, and 50 humpback whales. No time horizon to end the sampling. JARPA, first program, had a fixed time horizon and used the same permit to tell the IWC every year by photocopying that they were doing this. And here is a picture of the take of whales for scientific whaling. Again, this line indicates when the moratorium begins. So this goes back to about 1947 after the ICRW went into effect. And the red bars are the whales that Japan has taken under either JARPA or JARPA 2. The objectives of JARPA 2 were monitoring the Antarctic ecosystem, modeling competition, elucidation of temporal and spatial scales, and improving the management for minke whales. Again, very, very broad. Between 1988, when JARPA began, in 2010, Australia tried all sorts of different ways of getting Japan to cease the program of scientific whaling. It is a very big political issue in Australia. And they finally decided that the last alternative was to go to the International Court of Justice. And I'll talk about that momentarily. Australia filed in May 2010 its case in the International Court of Justice, in which it asked the court to basically order Japan to stop JARPA 2 by revoking all permits and ensure that Japan would not do something similar to this unless it was meeting all of its international obligations. I was asked by Australia to answer the question, what would a program for purposes of scientific research in the context of whales in the Southern Ocean look like? And then to assess JARPA 2 against those criteria. So remember, I was writing for a bunch of lawyers and judges. So it was actually quite fun, because this means I had to think about science as a process and how to explain science as a process succinctly to these guys. For example, in my second document, I summarized the history of the philosophy of science in the 20th century in 3 sentences. In order to you have to look at the document. I don't have them here. It took a lot of work to get there. Okay, so I actually answered the question by coming up with a detailed description of what it would mean to do science, a program of science in the Southern Ocean in the context of whales. Here, and then I assessed JARPA 2. This is about half of the material that I had to look at against those criteria. So here is my overall assessment. So that is, JARPA 2 was a program for collecting data, but not a program for purposes of scientific research. And there were 3 reasons that I gave. The first is it had no conceptual framework leading to testable hypotheses. Now, we can get into the arguments about testability or not, but Brian and Alan yesterday both talked about the importance of prediction. Right? If you don't have something you can test, it's not clear you can be doing science. The process for setting sample size of lethal take, and lethal take is what this was about, was impossible to figure out. There was no solid statistical reasoning at all. And most of the work associated with both JARPA and JARPA 2 was not published in peer review processes, and only about 15% of the papers that were both peer reviewed and relevant to the stated objectives. Okay. So then we went to the ICJ, which is in The Hague. You almost never hear about the ICJ on the news. What you hear about is the International Criminal Court. The ICJ is the International Court of Justice. It is the descendant of the Permanent Court of International Justice, which began in 1909. All member states of the UN are automatically member states of the ICJ, and they actually, if they don't want to be involved in an ICJ case, have to withdraw jurisdiction, which we'll come back to momentarily too. The court's role is to settle legal disputes between states. Only states can bring cases to the ICJ. I went and heard one in December 2012 between Peru and Chile. I wanted to go and see what it was like to be in The Hague and at the Peace Palace. So here are Peru and Chile, and there is their international border. And now there is great interest in marine resources extending off of the land. So the question is, how does one draw that border into the water in order to know who's got the control of which resources? Well, it's not surprising. Chile said, what we do is we go to the line of latitude and go across. And Peru said, no, 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 no. What we do is we extend that border, that land border into the ocean. So this is what the case at the ICJ was. It takes about 3 weeks of legal arguing, and then the judges make a decision. I'm going to come back to that too. And then you can decide once I show you the answer. Okay? So, there were 2 rounds of oral arguments. Australia went first, then Japan following long periods of time during which written arguments were prepared. After the first round of oral argument, there was a little break, and then there were 2 more rounds of oral arguments, and then the court took from July 2013 to March 2014 to make its decision. So now I'm really going to talk about the reasoning of the court, because I think for us, that's the kind of interesting thing. I'll point out, the court could have just punted on all this and said, well, this is a question of treaty interpretation, and if we look at what Japan is doing, it is following the specifications in the treaty, and that's that. And the 4 judges who dissented basically dissented for that reason. The majority of the court decided to actually review the program. And they said, we are going to look for an objective standard of review. And there was a lot of discussion in the case about motivations of people. And they said, we're not going to look at motivations, that's not our job, but we're going to ask whether the design and implementation of a program are reasonable in respect to achieving the objectives. And they actually talked again about multiple motivations. And this font and these paragraph numbers are from the judgment. I will quote the actual judgment quite a bit. It is a beautiful document. You can get it at the ICJ website, and if you're looking for something to read on an airplane ride home or an airplane ride someplace, it's wonderful. So the court recognized that everybody can have multiple motivations when they do scientific research. They weren't going to judge that, but they were going to say the research objectives alone must justify the program. So how did they do this? Well, they came up with a standard of review. I should mention, I gave this beautiful definition of, what I thought was a beautiful definition of a program for purposes of scientific research. Japan did not offer its own definition. It simply said, well, what does a scientist know about treaty interpretation? So that's that. But here's what the court decided it was going to look at. It was going to look at the decisions regarding the use of lethal methods, the scale and use of lethal sampling, the methodology used to select sample sizes, the comparison of actual and target sample sizes, the program's time frame, the program's scientific output, and the cooperation with other research programs. So to a very large extent, when I read what they did, they took my definition of what science is and put it in a framework that the judges could use for treaty interpretation. So the first thing they said, and this goes back to the Article 8, second paragraph, in which the scientific whaling is exempt from the convention, the court said, killing and taking whales is not simply a matter of a state's perception. That is, you cannot simply say, I'm doing this, I call it scientific whaling, it's done. That is, there has to be some kind of broad consensus and broad objective view of what science is. And the way the court did this was they said, well, we are going to first ask if the lethal take could be scientific research, and then second, if that lethal take is for purposes of scientific research, using reasonableness, again, as their criteria. And their view was that the two are cumulative. That is, something could be for scientific research, but not for purposes of scientific research. There were 2 other expert witnesses involved in the case, another for Australia, Nick Gales, and Lars Vowell for Japan, and all three of us agreed that, yes, lethal take can be part of a program of scientific research. And those of us who have done empirical work have often killed animals for one reason or another. So the judges put aside whether lethal take could be part of scientific research or not, and basically they put aside all the ethical questions then about killing whales and said, let's turn to, for purposes of scientific research. So the first thing they noted is that compared to JARPA, which took 400 whales a year, JARPA 2 took about twice as many minke whales and added fin and humpback whales. And the court could not look at the two objectives, that is the JARPA objectives and the JARPA 2 objectives, and see in the objectives what would justify doubling the number of minke whales and taking 2 additional species. I put them up on the same slide now. Now, I have not done a concordance, but if you just scan this, you'll see that there are really many, many words in the JARPA objectives that are virtually identical in the JARPA 2 objectives. So the court found no compelling separation of the objectives to increase the sample size. The sample sizes for fin and humpback whales were too small by Japan's own admission to provide any scientific information. The process for determining sample size for minke whales, the court says, lacks transparency. As everybody, Lars Vowell, the expert witness for Japan, also agreed. So nobody could actually figure out how that was determined. The court also noted what I pointed out to you, that JARPA 2 had sample sizes set before JARPA had finished and was analyzed, and concluded that maybe JARPA 2 sample sizes were not driven by strictly scientific considerations. Then the court looked at implementation. So the first was that no humpback whales were taken during the entire period of JARPA 2, and in fact during oral arguments, one of the counsel for Japan got up and said, well, yes, we kind of kept them in there so that we could be asked not to hunt them by other nations, and then we could be demonstrating good faith to the scientific community and goodwill to the scientific community by saying, okay, we won't take humpbacks. The take of fin whales was only a small fraction of what was actually called for, and in fact, the fin whales could not be randomly sampled because Japan does not have a vessel big enough to take adult fin whales. Third, the actual take of minke whales was in general much lower than the target sample. And although there were these big gaps, every year Japan gave the same permit, and those of you who are students or professors imagine your research doesn't go well when you have a problem in getting your samples. Would you adjust what you're doing or just keep doing exactly what you were doing previously? Finally, in the implementation, the court noted that Japan had set a 6-year period for determining minke whale sample size and a 12-year period for the other species, and the court could not understand how you could do anything at the end of 6 years if you were trying to model whales in the ecosystem, in which you wouldn't have data on the other 2 species for 12 years. And of course, if Japan had set a 12-year period for minke whale take, the sample sizes would be lower. And the court noted that 5 years of JARPA 2 had come along and been completed by the time of the case, and that there were only 2 peer-reviewed papers, and that actually neither of them related to the objectives of JARPA 2. And the court said, given that 3,600 minke whales have been killed, scientific output seems limited, which I think we would agree. Here's the decision, and final without appeal. When nations go to the ICJ, there's nothing left. The court decided it had jurisdiction. I can talk about that later if somebody wants to know. It concluded 12 votes to 4 that the special permits are not within Article 8. It concluded that Japan was violating the commercial moratorium. And Chris Greenwood's opinion, I showed him to you earlier, was very much about that. He said, it is inconceivable to me that a vessel could be a commercial vessel on December 31st and a scientific vessel on January 1st. Violated the factory ship moratorium and violated the Southern Ocean Sanctuary. It did vote 13 to 3 that photocopying the permit to inform the commission was okay. So then, by 12 votes to 4, it voted that Japan should revoke and cancel JARPA 2. This was a stunning judgment. Natalie Klein's the dean of Macquarie University, said usually people come out after the judgment has been read and they don't know if they've won or lost. They try to figure it out because the court tries to give something to each of the nations because participation in the ICJ is a cooperative venture. So now I come back to, you asked me, right, how did the court, yeah, okay, so here, you remember Chile, Peru? Yeah. Here's the decision. Okay, you begin with a line of latitude and you go out some distance, right? So that's kind of what Chile wanted. And then you go parallel to the land border out to the 200-mile where the 200-mile EEZs join, more or less. And that's what Peru wanted. So this was really quite a stunning decision. Even so, there were 2 missed opportunities. The first involves an evolutionary interpretation of the ICRW. Much like our Constitution, treaties can be interpreted in different ways at different times. That's what Gaia was talking about, Judge Gaia was talking about when I saw him in Oxford. So if you recall, the preamble talks about the proper conservation and the orderly development of the whaling industry. Australia argued that the international norms has changed so much between 1946 and 2013 that now conservation, which Australia interpreted as preservation, completely dominated the whaling industry. And the court said basically that the commission, the whaling commission, can give different weights to the 2 activities, but they, the court, cannot change the purpose of the convention. And Malgosia Fitzmaurice, who has published a wonderful book on whaling and international law, notes in it that the ICRW is just too constrained in order to take account of changes that have happened in the last 40 years. The second missed opportunity is what I am calling, I'm trying to create a new verb here, Daubertize, the Daubertization, that would be a noun, I guess, of international law. The court decided that they did not need to define scientific research. Now, there are about 40 international multilateral treaties that mention scientific research, none of them defining it. So the court missed an opportunity to do what the Supreme Court of the United States did in Daubert versus Merrill Lynch in 1993, in which our Supreme Court decided that the federal judge is the gatekeeper to ensure scientific expert testimony proceeds from scientific knowledge, that scientific methodology has to be used. Scientific methodology is a process of formulating hypotheses and then conducting experiments. And valid scientific testimony includes peer review, the acceptance of theories, all the things that we would say make for a good program of science. So let me tell you just a few events subsequent to the decision. Japan immediately canceled JARPA 2. And this decision came March 31st. That day was April 1st in Japan. Immediately, Japan canceled it. The big retailers stopped selling whale meat. But less than 2 weeks later, the Japanese government confirmed that it's going to continue pursuing the policy of resumption of commercial whaling by conducting research whaling. So Japan developed a new program called the New Research Program in the Antarctic that they felt, the Japanese felt, addressed all 7 points that the court used in its assessment. The IWC commissioners in September of 2014 voted a resolution, and these are non-binding resolutions, that no more lethal scientific programs would take place until both the scientific committee of the IWC and the commission had been able to review them. For the first time ever, the IWC sponsored an independent expert panel to review a proposal by a nation for scientific whaling, and New Rep A failed that review. The review took place in February last year. The results were published in April last year. The panel felt the proposal was insufficient. The panel made numerous recommendations that it felt were necessary to be completed, essential before the program could start. The panel also agreed that if there were a 2 to 3 year gap in the monitoring of the Southern Ocean, that would be just fine. And in summary, the panel said that with the information in the proposal, we cannot see a need for lethal sampling. In October this year, Japan wrote to the Secretary General of the UN, and it withdrew from compulsory jurisdiction by the ICJ in any dispute arising out of, concerning, or relating to research or conservation or management or exploitation of living resources of the sea. In other words, Japan did not know what Australia would do with New Rep A, but they were trying to cut off the use of the ICJ again. Australia and Japan went to the International Tribunal for the Law of the Sea about 15 years ago concerning bluefin tuna, and that case never got to the merits. Japan challenged jurisdiction, and that's when it stopped. So it's not clear what will happen, what other recourses Australia has, but the ICJ is no longer possible. Japan's fleet sailed south in November, and in December, Japan issued itself a permit for the lethal take in 2015-16. Okay, so I think there are a variety of conclusions, and I'm going to go from the specific to the more general. So specific to the case, I think the case to some extent shows that until the international norm about lethal take of whales has really changed, deciding whether whales should be killed is neither an issue of science nor an issue of law. And the court made a comment about that. You know, we recognize, they say, that different nations have different views of lethal whaling, and it's not our job to deal with that. We have 2 independent reviews of a program for purposes of scientific research at this point, and I consider that we are moving towards recognizing a pile of stones rather than a house, or the end of the abuse of science in these programs. JARPA 2 failed to be a program for purposes of scientific research, and New Rep A failed peer review. There's a new book coming out by Malgosia Fitzmaurice and Dai Tamada, which was a conference held in May 2014 about the decision. And in that, Tony Press from the Australian Antarctic Survey says that the judgment significantly raised the bar for lethal whaling. Now people have to answer in a more specific manner. In fact, because this judgment showed that non-experts can still objectively assess science, even if they don't get into the details. Sir Geoffrey Palmer, former Prime Minister of New Zealand, said that the standard of review of the court is demanding and rigorous, and Geoffrey Palmer sees that lots of other multilateral agreements will be affected by this because it reduces the wiggle room in all those other agreements in which there's talk of scientific research. Allison Reiser at Hawaii, the day of the decision, basically said that this is a good day for international law and for science. The third point is, for the first time ever, soft law has been turned into hard law. So this is the first judgment in which an international court or tribunal has told a nation that things which are not obligatory still have to be addressed. So many of the IWC recommendations were non-binding, and Japan more or less ignored them. The whaling judgment says response has to be made to these. And the soft law into hard law is that now one can no longer say, well, this is Article 8, we're using these lethal methods, that's that. Rather, the obligation is to explain the lethal methods and how they were derived at and how they will be used. Okay, so my overall conclusions is this is actually a very nice way for courts and tribunals to approach science. We can't expect judges to judge on science, but there are other ways that they can look at objectives and processes and results and move forward. This was the first time that the International Court of Justice had experts in the court, and the experts last appeared in about 1994. We were examined by counsel. I was examined by counsel for Australia, cross-examined by counsel for Japan, and then examined by the judges, the 16 judges. So it was kind of like a qualifying exam with 16 examiners, 300 people in the audience, and broadcast worldwide. Okay, and I'm going to leave it to Malgosia again. Lawyers frequently do not feel comfortable with science. As Jane talked about yesterday, it's our obligation to work with them so that we can communicate the science to them, because science and law are often going to be interacting in all sorts of environmental cases, and they're two sides of the coin. Okay, so with that, I can take a few questions, I think.